Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. Hello, everyone. Welcome to the podcast. I am so excited. We have as a very special guest today, Greg Valenza, who many of you know, we started our firm together in 2006. He decided not to continue practicing law for lots of fabulous reasons. So we're here today because this is today our law firm's 18th anniversary, which is really hard to believe because I remember when Greg and I were driving around Oakland looking at the design lady who was going to help us with stuff. It's crazy. You guys, this is a special treat because as many of you know, if you've practiced with Greg or he has been your lawyer, he was certainly one of the preeminent employment lawyers in California, litigated the early class actions under PAGA. He's pretty amazing. So we're going to talk about a bunch of stuff here today. And guess what? We're going to go on for more than 15 minutes. So Greg, thank you so much for coming today. How are you?
I'm well. Thank you. Thank you for having me.
Well, it's such a treat. And, you know, when we were thinking about what to talk about during the podcast today, I was really thinking about this idea of what has changed since we started practicing law together. I mean, I obviously practiced with you at Jackson Lewis a long time ago, and then we opened our firm. But there's been a lot of good stuff. Like I've been thinking about all the things, like pot, for example. I mean, who thought? Like you litigated a huge case about medicinal marijuana, right? The Raging Wire decision. And then here we are, and now you can buy pot on the street. Now, new laws are saying that we can only test for psychoactive metabolites. I mean, what is going on? Talk to me.
Well, there's people micro-dosing magic mushrooms, which, or psilocybin. You can't call it, you have to call it psilocybin because if you call it something colloquial, then it takes away the serious medicinal need to have it.
Oh, yes.
Like cannabis, because we can't say pot. We have to say cannabis. Anyway, what hasn't changed really in all the time we've been together, and beginning with the fax machine, the elimination of that to email, to Slack, and technology's been one of the big changes. But a lot of the things we do as lawyers to provide help to clients, the mechanics of it has changed in many ways. But of course, substantively, the amount of change in the law is breathtaking, such as the stigma of being under the influence or high or whatever. You're still not supposed to be intoxicated when you come to work, but used to be you had to hide that you were a user of materials like marijuana or magic mushrooms or whatever. And now there are CEOs encouraging creativity and the like. So that's certainly a big deal, but I don't think it's the most significant thing in the workplace. I mean, let's just look at all the things the pandemic did, such as remote, work from home. And even before the pandemic, we had, there was a movement towards that with the expansion of broadband. I remember that, then the government was saying that you had to set up people's home offices to comply with OSHA rules, and there was privacy, what could you monitor in somebody's home because it's a different legal landscape. So much that the pandemic did besides work from home, the shutdowns, reopening, the shutdown, the reopening, what are all the wage and hour issues that came up? All of a sudden, employers had to be worried about what people were doing medically in terms of vaccinations, which used to be verboten, right? The PPP money. I mean, so many things became new or different. The calculus changed. Every time you shut down in the middle of the week, did you have to pay the exempt employees? I mean, there's so many things that happened. Changes that have also occurred used to be what you did outside the workplace. The government was very interested in that remaining your personal business, and now we have a social media Greek chorus sitting there trying to or threatening to, and actually calling up corporations, board of directors, and CEOs and demanding people be fired for what they do outside of the workplace, if not in the workplace, right? Uh, I mean, the attitudes that have changed along those lines in privacy and in who is responsible for what you do outside of the workplace, the canceling phenomenon, whether or not you agree that there's such a thing as canceling, there certainly is a group of people who will contact your boss and try to have you removed from a position. Used to be that we would recommend doing adequate investigations and training as part of sound employee relations, and that has now become legal mandates through statutes and case law, right? And the ticky tack, what I consider to be very small wage and hour violations, which you could call it. You have to put a spin on it, like wage theft, but we're talking wage theft of a minute and a half. Yes, would it be better to pay the minute and a half? Yes, but should you be fined tens of millions of dollars because somebody got a minute and a half deprived of their wages times 100,000 employees, right? Times 4 years. And, there has been a major shift in what is considered to be discrimination law and the DEI. There used to have ESG. Now there's DEI. The George Floyd events and protests were certainly watershed events, and now employers are seemingly outwardly engaging in what traditionally was known as discrimination, and which has not yet been ruled non-discrimination under the law. So we've talked about things, how they've changed, but the thing that stays the same is employers are still between a rock and a hard place, because if they don't get on board with some of these things, then they're going to get in trouble. And if they do get on board, they can certainly get in trouble as well.
So, Greg, it's interesting when you talk about being between a rock and a hard place, because I went to this presentation the other day about AI and lawyers, and the speaker was saying, oh, well, AI is going to take the job of lawyers. And one of the things that I thought of was employers are always between a rock and a hard place, right? When we're talking about investigations, how far do you go? How many people do you need to interview? You want to do training. Well, sure, you want the best training. It better be live training, but can you use a video? And what kind of video? And do you have to meet X requirements and Y requirements? I don't think we're ever going to be out of a job. I just don't, because I think there's so much that has to be done. And it's funny, when you were managing this firm, a lot of obviously the managerial responsibilities fell on you. Now that I'm doing that, I just have even more empathy for our clients about how they can possibly run a business with this regulatory framework. It is really tough. And we haven't even talked about how fast food workers get $20 an hour in California, unless you work at a bakery where you make bread that weighs at least 1.5 pounds. If it weighs 1.25 pounds, that's probably not enough. So one of the things I think is so interesting are all these exceptions. Like there's rules that come out, and then there are these exceptions that we're all supposed to figure out. When you were talking about COVID a moment ago, I was thinking about, we gave these free webinars on Wednesdays to employers to just try to help them figure out what was going on. And honestly, it was self-serving for us because that made sure that I was on top of everything. But sometimes regulations, rules, guidance would change 3 times in the week between Wednesday and Wednesday. So this rock and a hard place theme, I think that's where employers really find themselves a lot. And interestingly, it's not just California, right?
No.
Yeah, we have a lot of clients who are all over the place. And they say, oh, well, California's the worst. Well, in some ways, but we just got the Pregnant Workers Fairness Act, a federal law that is more protective of pregnant women than the Fair Employment and Housing Act is here in California.
Sure.
You don't even have to be able to perform the essential functions of your job to be entitled to coverage. So, I mean, we could go on for days. All right, here's something that I'm really interested in. You were such an important mentor to me in my career, teaching me how to be a good lawyer, teaching me how to talk to clients, how to understand what their problems were, how to solve their problems. Is there anything you didn't do in your career that you wish you did? Like, you had a good long run. What kinds of things didn't happen or that you wished you had been part of?
Well, I mean, we did a lot of things, both at Jackson Lewis, that I'm happy about and proud of, and I think we accomplished a lot as Shaw Valenza and now Shaw Law Group, probably to a greater degree than a lot of smaller operations could say. I mean, while I was practicing for almost our whole time together, my focus was on litigation. You trained them, and if they didn't listen, then I got the lawsuit. But if a lot of times when you go through these cases, between the insurance company that often is involved and, of course, the clients and the executives, they don't want to be involved in litigation. So most cases go away through some sort of settlement. And the more that happens, the more litigations will occur, because the plaintiff's bar knows that sooner or later they'll get some sort of payoff. So whereas when you used to take everything to trial, because trials were much simpler, then it was more likely that there was a bigger risk to the plaintiff's bar. So it could either settle for almost nothing, or you'd win summary judgment, which is an expedited way of getting a case tossed out. Summary judgment is all but gone. The plaintiff's bar became very sophisticated at creating disputed issues of fact that could only be resolved at trial. So this is a long answer to say it would have been fun to have more trials, because of the few trials that we did have, we won. Ironically, we often talk about the pros and cons of arbitration. I think I had a couple of arbitrations and that was my only loss at Shaw Valenza. I lost an arbitration, and I would have liked to have more jury trials. I would have liked to argue at the U.S. Supreme Court, because it's a once in a lifetime or opportunity for most lawyers. I know, and
You were so close.
we
You were
briefed
so
things
close
to
on
the
that.
United States Supreme
Oh,
Court, but that's not the same as the argument, even though the briefing is probably more
yep.
important. Certainly, I would have liked to just see that some of the articles and input that we had with some people in the state, I would have liked to see that translated into maybe modified policy, or at least somebody saying, these people might have a good point here, but it
Yeah.
really didn't
Yeah.
come to pass. And that sometimes was unfortunate. I mean, I wrote a lot of sassy blogs, and I wrote a lot of substantive blogs that were very, I thought, analytical. And so it would have been nice if somebody once would call and say, hey, I think you're right. You found a flaw in the law or something that could be improved. And one
And
of
we're going to
the
fix it.
Yeah, and one of the
Yeah.
main things that, as I recall, and when you just brought up the exceptions and except on Tuesday when the moon is full sort of law, that's because of lobbyists and because of
Yes.
horse trading at the legislature. And one place where that happened a lot is with that independent contractor
Oh,
situation. And,
yes. Yes.
remember all the analysis that had to be done to see if somebody could qualify as an independent contractor. And we pointed out quite a few problems with that law, which resulted in not our criticism, but a lot of people pointed out the flaws, which resulted in a whole new replacement law.
AB5.
Yeah,
Yep.
85. Anyway, so long way of saying that regrets, I've had a few, but then again, too few to mention.
There we go. Well, and look, there were so many good things while you were here, and your career was full of, you did win jury trials. You trained so many good lawyers. I mean, I think of so many lawyers who have worked with us and what they're doing now, and their professional development. And I often think when I'm working with our lawyers in the firm right now, what did you do to teach me, and how did I pick up on what needed to be done? Because I think a lot of people forget that we're lawyers, so the client calls and we help them solve a problem, but we're also learning a business, we're running a business, we're teaching people how to be better lawyers. So there's a lot that goes on that isn't written on your timesheet. That's not a point one. And I think a lot of times, until you go through it, certainly until I've gone through it as now managing the firm, realizing what all of that work is. And now if I can bill 150 hours in a month, it's crazy. I mean, usually I'm 100 hours. There's no way I can get more because I'm too busy doing non-billable things. What do you miss most about practicing the law?
Well,
I mean, other than expense accounts, of course.
There was a great sense of accomplishment to be one guy on the phone with, maybe a publicly traded corporation asking you a question that could, if answered incorrectly, result in great liability, or a corporation representative who needs help understanding why California is different and why, even if California is the same, why their approach to a situation may not be consistent with what the law is. A lot of times we don't know exactly what the law is because there hasn't been an explanation by a court or by an agency, and we're trying to make our best estimate of how to best comply with something. And it was intellectually a blast to come up with a solution to a challenge where it was always a defeat to say can't be done. And the goal
Right.
of my practice was always to find a way. Now, that way may not be practical. That's why it was important for me to try to know as much as I could about the business and about what they wanted to accomplish. I mean, if somebody had a compensation plan, for example, they want to get from A to B with the compensation. They want to incentivize. They want to not break their bank, etc. And my job was to find a way to fulfill those goals in a way that complied with wage hour law, which is not always the easiest thing to do. It's just an example. Same thing with terminations and accommodations, and
Right.
and in the case of a small business, those kind of issues like accommodations could wreak havoc, because if somebody was important to a small business, there's not another person to step up. It becomes quite difficult to convince those people that just whacking or terminating or whatever somebody
Right.
is potentially a problem legally, but the person is telling me on the phone, yes, but I have to be able to run my business, and I can't just sit there and say, poo-poo, let's look at the large, thick book full of regulations. These are real people with real issues. And so, it felt really good to get to that end game. It felt really good to convince very smart people, either as judges, appellate justices, opposing counsel, and clients, that I had the better of the argument.
Yes.
It
It
really
feels
does.
good, doesn't it?
It does.
Yeah.
It does. And
No, it does.
And to have somebody say, you know what, the guy was right, is nice, because it means that I did the work that I was supposed to do, and I used my my talent and my ability to reason and to find the law. And those are, very difficult things to acquire, and they result in a lot of gray hair early, and such.
Yes, yes. Well, it's funny because when we've really taken that to what our whole premise is in the firm, right? When you left, we stopped doing litigation because I said, if Greg's not here to do the litigation, I don't want to do the litigation. Like, that's not what I want to do. And we were worried about it, right? We were thinking, like, is there enough work that's not litigation work? But we have so much work in advice, training, investigations, labor commissioner hearings, CRD, position statements with the EEOC and the Civil Rights Department and all of that. There's plenty of work because you know what? Nobody really wants to be in court. I mean, I always felt like when I was in court at trial too, and I only had a few trials, I was having more fun than anyone else because they're sitting there, our client is sitting there paying the bill for every second, and they don't know what the result is going to be. And like you said, they're trying to run their business. So we talk a lot amongst ourselves in the firm now about our job is to solve the client's problem and not to let our ego get in the way, right? Look, you may have a solution that they don't like or they don't want. That's fine. A lot of the lawyers will tell me, well, but Jen, they're not going to do what we told them to do. That's okay. It doesn't matter. We told them a way to do what they want to do. It's more risk than they want to take. So we gave them options. And now they need to make the decision they want to make. I think one of your clients, in fact, Greg, who we won't say the name of it, but it's a law firm. And they have a lot of partners who are very smart and brilliant. And I had a call with them this morning. They're on the East Coast, 5 a.m. I'm up, we're talking. And they can't make a decision to save their lives because they all have different ideas and concepts about what's going on. And I finally had to say, look, here's what you want to do. Here's how you can get there. If you don't want to do it that way, then we have to go down another road, right? And the idea is just for the people listening, I think, to understand how to best use your counsel. Like, ask them for options. Ask them for what they recommend. What's the most risky? What's the least risky? But in the end, we're not going to make the decision for you. We can't. We don't run your business. All we do is help you, stay hopefully on the right side of the law. So tell me about this. You've had some crazy things in your practice, and so have I. What are the ones that sort of come to mind as, okay, I cannot believe this happened, or things that people wouldn't believe are actually true?
I wish we could have had this conversation a couple of years ago because I think I've blocked out a lot of these because I know there are more. I've tried to sit down and think of a couple. And one of the oddest things I ever had was there was a sexual harassment lawsuit where it was a young woman and she was involved with another employee and etc. And it was one of my earliest depositions I took was the psychiatrist that this employee was claiming would stand up and say that she had post-traumatic stress disorder and repressed memory and a bunch of things in the early 90s that were sort of cutting edge because this doctor was treating her for emotional distress. So it just so happens that right before this person's deposition, this doctor, I took the deposition of the plaintiff's mother, who went through her marriage history because it was relevant to emotional distress that this person might have suffered independently of the workplace. And one of the people that she was married to, she said, John Smith was my other husband. He's a psychiatrist. And I looked up and I said, John Smith, MD? And she says, yeah, so John Smith, MD came in next to have his deposition taken. And he was not saying that he was the stepfather of the plaintiff. He said he was her shrink. And, he was going to testify to her gross emotional stress. So that was a big deal.
Oh, yeah.
Yeah. I had a sexual harassment case in San Diego where a man who was clearly a bodybuilder, he was huge, and he was claiming sexual harassment by this woman who looked like she was in a Norman Rockwell print. who was just older. She had very little physical ability to cause the kind of terrible treatment that this man was claiming. So we tried to have to convince a jury that we actually went to trial on that, and she lost. I mean, he lost.
He
The
lost.
manager
Good.
won.
So there is justice
Yeah,
occasionally.
right. And then another weird one was that we had another sexual harassment case, and the plaintiff claimed that rap music in the workplace was offensive. It just so happens that it was an electronics store where they had audio equipment, and they would, of course, the customers would want to test out the kind of music that they liked. So they would play these rap CDs. It was what they call gangsta rap at the time, and it was quite dirty, I will say. But the
Uh huh.
plaintiff, being 21 and from L.A. and whatever, and she was a fan of rap music, it was a stretch for her to claim that she was offended. So anyway, we had a big fight, and the judge decided that he was going to listen to the music to decide if the jury
Oh,
should hear it because it might be too prejudicial, and took the music into the chambers and played it. And outside of his chambers was an entire courtroom full of the morning's calendar and all these people in
oh
suits waiting
my
for their
gosh.
case management conferences. And the music was something. The recordings were something. So anyway, what made this one of the weirdest things was, we got done with our hearing. They opened the door to the chambers. We all stepped out, and everybody in the
Oh
audience
my
is like
gosh.
sitting there with their mouths agape. It was pretty funny. Anyway,
Oh, I
I
love it.
wish I
I
had
love
more
it.
weird. I know there have been weirder stories, but I just can't remember them.
Well, sometimes I think in our practice, there's something that comes up every day that's just a little
Yeah,
weird, right? There's so sometimes, they don't stay in your memory for long. Well, I know we need to wrap this up soon, but one of the things I think that would be helpful to folks is to think about and try to give them some perspective about what might be coming in employment law. Like I've talked already about artificial intelligence, and there is a lot that comes up there in terms of, if we're using certain automated systems to screen resumes and to try to help with selection criteria. So there's a lot going on there. What do you see as the big things coming? And part of it, I think, is sort of it's kind of an arc, right? Like these things come and go. But like unions now, right? Like what's going on with unions? For a while, we didn't even talk about unions.
sure. This administration, federally, of course, is very friendly to the labor movement. And at one point during my practice, I think private sector unionization was at about 6%, and it's much higher now.
Yeah.
The problem being that there are no trained or very few trained labor lawyers who handle union representation, and the laws regarding what is legal and how to conduct a union organizing campaign have changed dramatically because of the National Labor Relations Board's interpretations. What happens is a new administration comes, they appoint different members of the National Labor Relations Board, and then those rules change again. So the thing is, the public's acceptance of unionization has greatly improved. Politically speaking, people are more likely to see the benefits of unions. And what does that mean? That means there has to be, um, legal compliance with what the law requires vis-a-vis bargaining and vis-a-vis administering union contracts. And it's not all intuitive. It's quite confusing, in fact. And, another irony is that normally union disputes with a union member are primarily handled through arbitration, which, of course, is another thing that people hate or not. Then, another thing that's being talked about is that the 40-hour work week is something that
Yes.
needs to be eliminated. Many years ago, I read a book called The End of Work, in which the author said that the 40-hour work week was on borrowed time, and it turns out he was right. Thing is, in California, the 40-hour work week is almost in the Constitution because they won't allow flexible scheduling and the things that would be the alternative. You know,
Right.
the employees don't want the 40-hour work week to disappear if it means they're not going to receive compensation.
Right.
So
They want 32 hours of work
for
for
40
40
hours
hours of
at least.
compensation.
Yeah,
Yeah, right,
sure.
of course. Well, and now we just had
From
a law
home.
or a bill, right, from home, of course, while they're doing the laundry. The legislature here in California just introduced a bill. I think it's AB 2751, talks about the right to disconnect. So,
Right.
like, now we need to make sure that no one is calling employees at home. Now, listen, if you have a non-exempt employee, you shouldn't be calling them at home. Like, that better be a darn good
Sure.
reason why you're calling anybody. But the fact of the matter is, we have to legislate that. I mean, it's crazy right now. There's so much that we're having to try to deal with. And a lot of it, I think, is because of COVID, because we all used to say, oh, you're not effective if you don't work at home. Oh, you can't be monitored. Oh, we won't know about your productivity. And then what does everybody do during COVID? They sent everybody home to work. And guess what? Everything was okay. Not necessarily as good as if they were in the office, but good enough. So then the employee comes back and says, well, you let me work at home during COVID, so you should let me work at home now. So it was sort of like, I think it ripped off the Band-Aid in a way of all these cultural things of 40-hour work week, right to disconnect, flexible schedule. Oh, as the
Well,
employer, I have to give you a guaranteed schedule, unless, of course, the employee wants it flexible. Then it should be flexible for the employee,
performance
right?
appraisals are insulting, and there's so
Yeah,
much of these cultural changes that go along with what you're saying. But work from home is a major one. I mean, it's funny because even before the pandemic, we started seeing, well, people should be compensated if they have to take their truck home, or they have to, if they have to turn on the computer to log in, the day should start then. I mean, all these things have been bubbling around in the law, and now there will have to be changes to the laws because the existing laws really don't accommodate some of these. Another, you know while you're on the subject of changing in culture, I find that the workplace is getting older. They've been talking about it for a long time, but now people are starting to recognize that birth rates are decreasing, and the current generation is much smaller than the previous generations. And so there will be a greater proportion of older adults in the workplace. Younger people, time immemorial, have had some degree of contempt for older people. They used to say respect your elders, but that went out, 50 years ago. Now they say, okay, boomer. Ha ha, that's so funny. It's
right,
illegal.
right.
And if you said, okay, boomer, and I was able to capture that in an email, I could prove age discrimination against you. And so, if I were a plaintiff's attorney, so what I'm saying is that there's many things from disability discrimination law that is going to require more attention because of older people having greater incidence of disabilities, to technology. Is there a right? Is there an obligation to train an older worker as new technology comes out? I had a lawsuit about that 20 years ago, and the court said absolutely not. The guy didn't know
Right.
how to use the particular computer the way that he was supposed to, and so he was left behind, as it were. But maybe that'll change as the workforce ages. AI is something I don't think even I can say I understand it. I see what aspects of it are. It's going to affect a lot of things that people do routinely, much like email took over for the fax machine. AI,
Hmm.
you talked about employment lawyers. The employee handbook may get, we review employee handbooks. That sort of rote stuff, policy development, union contract clauses. AI can help with those things. AI
Right.
can't help with subjective judgments.
Right.
Maybe it can, maybe it can't. we'll see. But if we have to be able to coexist with technology as we always have, um, and employment lawyers, like you say, will not be completely replaced. But it's not really AI's effect on employment lawyers. It's what's going to happen to employment law as these systems are taking over for what employees do. And what about these AIs that are flawed, that are importing biases that the programmers have put into the system? I mean, is the employer going to be held responsible? So many things. But I'm looking forward to viewing from my cozy armchair, completely uninvolved in being responsible for practicing. But it's going to be interesting to see what these new developments are. I mean, I wouldn't be able to keep up with the things that have changed in the couple of years that I've stopped practicing.
That's the hardest thing to do, I think, Greg, is, how I have to get up 3 hours earlier to read everything to make sure I know what happened yesterday so that if somebody calls me for advice about that issue, I actually know something. I could do this with you all day. I
think we did.
I think we did, right? Thank you so much, Greg. We miss you so much. And I just love these chats. We used to be able to do this all the time. And it's so great. And I just want to thank you for being such a great friend and such a great Uncle Greggy to Ella, and just being so awesome. Super TP.
Thank
all right?
you very
Greg,
much.
Thank you.
Thank you very much for having me. Thank you for being my partner for all those years. Thank you for taking me along on your ride. It was an amazing partnership.
Ditto. We had a great time. Everyone, thanks for joining us today. Go out and do something nice for someone, and we'll see you soon. Thank you. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.